Hello, my name is Luke Pinto, and I am going to be going through my final theme presentation for EDU574. My topic for this project was child abuse with a focus on Pennsylvania law. First, what we have to talk about for this topic and this theme is what is child abuse? The Federal Child Abuse Prevention and Treatment Act, or CAPTA, stated in the United States Code annotated subsection 5106 defines child abuse and neglect as, at a minimum, any recent act or failure to act on the part of a parent or caretaker which results in death, serious physical or emotional harm, sexual abuse, or exploitation, or an act or failure to act which presents an imminent risk of serious harm. Most states, including Pennsylvania, recognize four major types of abuse: neglect, physical abuse, sexual abuse, and emotional abuse. When we talk about child abuse, some may think this is a rare thing. However, almost 3 million reports of possible child maltreatment were made to child welfare agencies in the year 1999. Approximately 60% of these reports were investigated. 826,000 children were estimated to have been victims of child abuse or neglect in 1999. Of these victims, 58% suffered neglect, 21% suffered physical abuse, and 11% were sexually abused. Today, it is believed that over 1 billion minors between the ages of 2 and 17 years of age have endured violence, either physical, emotional, or sexual. That is far too many. Now, as I stated, the four types of child abuse are neglect, physical abuse, sexual abuse, and emotional abuse. These definitions are listed for Pennsylvania according to the Pennsylvania Child Protective Services Law. Neglect. This is a failure to provide for a child's basic needs. Neglect may be something that is physical, but does not always mean it is physical abuse. For example, this could be failure to provide necessary food or shelter, or a lack of appropriate supervision. Neglect could be medical, failure to provide necessary medical or mental health treatment. It could also be an educational neglect, failure to educate a child or attend special education needs. It could also be emotional neglect. For example, inattention to a child's emotional needs, failure to provide psychological care, or permitting the child to use alcohol or other drugs. Physical abuse is physical injury. This could be ranging from minor bruises to severe fractures or death as a result of punching, beating, kicking, biting, shaking, throwing, stabbing, choking, hitting with any object, burning, or otherwise harming a child. Such injury is considered abuse regardless of whether the caretaker intended to hurt the child. This is even tough for me to present because thinking about those things is scary that it happens at such a high rate. The next type of abuse is sexual abuse. This includes activities by a parent or caretaker, such as fondling a child's genitals, penetration, incest, rape, sodomy, indecent exposure, and exploitation through prostitution or the production of pornographic materials. This is defined as CAPTA as the employment, use, persuasion, inducement, enticement, or coercion of any child to engage in or assist in any other person to engage in any sexually explicit conduct or simulation of such conduct for the purpose of producing a visual depiction of such conduct, or the rape, and in case of caretaker or interfamilial relationships, statutory rape, molestation, prostitution, or other form of sexual exploitation of children or incest with children. That is a lot, and it happens, like I said, in 1999, over 11% of the cases were sexual abuse. Emotional abuse is a pattern of behavior that impairs a child's emotional development or sense of worth. This may include constant criticism, threats, or rejection, as well as withholding love, support, or guidance. This one is often difficult to prove, and therefore Child Protective Services may have a tough time intervening without evidence of harm to the child. As we dive further into this theme presentation, there are 4 child abuse laws or legal documents that talk about child abuse. First, there's the Child Abuse Prevention and Treatment Act, or CAPTA. This is something that I've used a definition from in this presentation. There is the Child Protective Services Law of 1975, Pennsylvania State Law, Chapter 63, and the Pennsylvania School Code. CAPTA was started in 1974 when Congress enacted it. It is focused on preventing and responding to child abuse and neglect. As part of CAPTA, states receive grants and funds under this act that are and states are required to have procedures in place for receiving and responding to allegations of abuse or neglect and for ensuring children's safety. Child Protective Services Law, or CPSL, is part of Chapter 63 and was added in December 19, 1990. The purpose of this chapter is to encourage a more complete reporting of suspected child abuse, to the extent permitted by this chapter, to involve law enforcement agencies in responding to child abuse, and to establish in each county protective services for the purpose of investigating the reports swiftly and competently, providing protection for children from further abuse, and providing rehabilitative services for children and parents involved so as to ensure the child's well-being and to preserve, stabilize, and protect the integrity of family life wherever appropriate, or to provide another alternative permanent family when the unity of a family cannot be maintained. Pennsylvania State Law, or Chapter 63, there are 5 major parts. Subchapter A talks about encouraging a more complete reporting of suspected child abuse. Subchapter B talks about provisions and responsibilities for reporting suspected child abuse and the details of the role of a mandated reporter. Subchapter C describes powers and duties of the department, and the most important aspect is to establish a statewide database of protective services. Subchapter D creates organization and responsibilities of child protective services. Every state should have and needs to have an agency. Pennsylvania School Code of 1949 has a section 1205.6, Child Abuse Recognition and Reporting Training. School entities and independent contractors of school entities shall provide their employees who have direct contact with children with mandatory training on child abuse recognition and reporting. There should be 3 hours of training every 5 years, which is on the low end and could be upped. And I think that these laws had some really important outcomes. They produced children and youth services, mandated reporting, the child welfare portal, and Childline. Children and youth services is to provide welfare services designed to protect children from abuse and neglect. Each county has a children and youth service agency. Mandated reporting is stating that a mandated reporter is required by law to report suspected child abuse. Anyone that works with children is a mandated reporter and must follow the stipulations set in place by the laws that I previously spoke of. There is a serious consequence for failure to report or to refer. A person that is a mandated reporter will face severe punishments, as listed here, if they do not report a suspected child abuse of any type. Whether they think it is true or false, it must be reported. We also have the Child Welfare Portal. The goals of the portal is to provide safety from abuse and neglect, permanent stable homes and lifelong relationships, family support for each child's physical, emotional, behavioral and educational needs, a support system that helps families thrive in their homes and communities using accessible services that build on strengths and address individual trauma, needs, and concerns, strengthen families living together in safe, nurturing, and healthy environments, skilled and responsive child welfare professionals. It provides a place to report suspected child abuse, and it also manages PA child abuse history clearances, something that all educators need to have. Childline has trained specialists that are available 24/7 to receive referrals of suspected child abuse and general child well-being concerns. Each report is handled by a trained specialist who determines the most appropriate course of action. They can refer to county children and youth agencies or Office of Children and Youth and Families. They can set up with law enforcement officials for investigation or the Department of Human Services program offices for review and possible licensing action. You can also call Childline to report at 1-800-932-0313. As we go through this topic of child abuse, there are two very important Supreme Court cases that set forth precedent when it comes to child abuse. First, we have DeShaney versus Winnebago County Department of Social Services of 1989 and Ohio versus Clark of 2015. In the case of DeShaney versus Winnebago County Department of Social Services, Joshua DeShaney, a 4-year-old, suffered beatings that led to a coma and intellectual disabilities. The Winnebago County Department of Social Services took various steps to protect the child after receiving numerous complaints of the abuse. However, the department did not act to remove Joshua from his father's custody. DeShaney's mother sued, claiming that they should have removed him. The question of this Supreme Court case is, does a state's failure to protect an individual against private violence constitute a violation of the Due Process Clause of the 14th Amendment? The answer is no. The Due Process Clause does not impose a special duty on the state to provide services to the public for protection against private actors if the state did not create those harms. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security. While it forbids the state itself to deprive individuals of life, liberty, and property without due process of law, its language cannot fairly be read to impose an affirmative obligation on the state to ensure that those interests do not come to harm through other means. As we move on, Ohio versus Clark of 2015. In 2010, a teacher of Cleveland's William Patrick Day Head Start Center was told by a 3-year-old student that they were abused by Darius Clark. Prior to trial, a judge ruled the 3-year-old child was incompetent to testify, but refused to exclude the child's out-of-court identification of Clark as his abuser. Clark was found guilty. On appeal, Clark claimed that the admission of the child's out-of-court statements violated the Sixth Amendment right to confront the witnesses against him. The issue is, rather than reporting the evidence, the teacher was acting as a law enforcement agent and the testimony could not be deemed valid, in addition to accepting a 3-year-old's testimony outside of court. The questions of this case. Does an individual's obligation to report suspected child abuse make that individual an agent of law enforcement for purposes of the Confrontation Clause? And number 2, do a child's out-of-court statements to a teacher in response to the teacher's concern about potential child abuse qualify as testimonial statements subject to the Confrontation Clause? Both answers to the previous questions are no. The court held that the 3-year-old statements to his teacher were non-testimonial because the totality of the circumstance indicated that the primary purpose of the conversation was not to create an out-of-court substitute for trial testimony. In this case, there was an ongoing emergency because the child who had visible injuries could have been released into the hands of the abuser, and therefore the primary purpose of the teacher's questions was most likely to protect the child. Moreover, a very young child who does not understand the detail of the criminal justice system is unlikely to be speaking for the purpose of creating evidence. Finally, the court held that a mandatory reporting statute does not convert a conversation between a concerned teacher and a student into a law enforcement mission aimed primarily at gathering evidence for a prosecution. As we went through all of these issues, laws, and solutions to child abuse with a focus on PA law, we learned many things, but we learned that we have taken huge steps to lower the number of child abuse cases and also the way we deal with them. As we move forward, we hope to reduce the number of cases and increase the efficiency in which we handle child abuse, not only in Pennsylvania, but in the entire nation. Here I have listed the works cited where the information was gathered and brought to you for my final theme presentation. Thank you very much for listening, and have a good day.